If you are the named victim in a domestic violence case and you were served with a subpoena, but you don't want to go to court and you don't want to testify, you're wondering what your options are, this video is for you. My name is Veronica. I am a criminal defense and domestic violence restraining order attorney here in California, and I help people who have been arrested or been served with a domestic violence restraining order put their cases behind them so that they can enjoy their lives and their freedom. But this video is a little bit different than most of the videos that I make because this is for people who are alleged victims of domestic violence. Okay, so if you were served with a subpoena in a domestic violence case, it says that you're subject to arrest if you don't show up to court. Now that part is true, but there are 3 ways that you can avoid testifying in a domestic violence case as the alleged victim. Number 1 is there is Code of Civil Procedure, section 1219, which says that you cannot be jailed for not testifying in a domestic violence case if you are the victim. Now, if you look on some criminal defense attorneys' websites, if you look that up, Code of Civil Procedure, section 1219, you will see that a lot of those attorneys say that it means you don't have to testify. But that's not exactly true. You can still be fined. You can still be held in contempt of court. You can still potentially have a criminal record for it. You just can't be put in jail. So it's not that easy to just show up and say, I don't have to testify, and you definitely do have to show up. So let's look at the 2 other reasons. And I actually just used the second reason with great success in another criminal case. Okay, so the second reason is to plead the 5th. So what happens basically is you go on the stand and you are asked a question about what happened and you say, I refuse to answer on the grounds that it may incriminate me. And you may be thinking, well, Veronica, what do you mean incriminate me? I am the victim here, or the alleged victim. I'm not the defendant. But here's the thing. In any kind of person-to-person crime of violence, there is always the possibility of self-defense being what the defendant asserts in the case. Self-defense means basically that you started it. So by pleading the 5th, you're not incriminating yourself, but you are implying that perhaps you started it. And the judge may appoint an attorney for you if you don't have an attorney at court for you already. But the judge is not going to, in most cases, compel you to testify. You may still have to say your name, that you know the defendant, point the defendant out in court. But when the prosecutor says, okay, and on the night of July 3rd, 2022, what happened? You can say, I refuse to answer on the grounds that it may incriminate me. You're pleading the 5th. And you don't have to give details as to why you're pleading the 5th. That's important to know. Number 3 is spousal privilege. So if you and the defendant are married, then you can not be compelled to testify against the defendant. Now, if you're thinking, okay, perfect, we were thinking about getting married anyway, be careful. Make sure that there is not a restraining order in place. I've actually had a case before my client and the alleged victim, there was a restraining order in place that the prosecutor put on them, or put on the defendant. And they got married while that was in place. They were not supposed to have contact with each other, but they got married. So they obviously did have contact, and they wanted to assert spousal privilege. But the thing about doing that is that then you have provided evidence of a crime. So that is the 3rd one. Now, you may be, if you're searching YouTube or searching the internet for information about this kind of stuff, looking to DIY this. I will tell you, it is not that easy to go on the stand and assert your rights as the alleged victim. I take cases, I used to not, but I take cases for victims who are trying to avoid having to testify because many times it takes me going up with the witness on the stand. And what I actually do is on the back of my business cards, I will write the different things for them to say. So I refuse to answer on the grounds it may incriminate me. I refuse to answer on the grounds of spousal privilege. I refuse to answer pursuant to Code of Civil Procedure, section 1219, and I'll point to them to make sure that they give the right one. And then sometimes I'll have to argue because the prosecutors get pissed off when you do this. They hate this. Most people don't know about this. That's why I'm telling you right now. And so it really helps if you do have a lawyer there to argue these cases with you. And it can be hard to find one. You know, I used to never take these cases because when people call criminal defense lawyers all the time as victims of a crime because they want to prosecute. And it's like, look, that's the opposite of what we do. Sorry. That's what the DA is for. We don't do that here. You know, if you want to file a civil suit or something, call a civil attorney, but we don't do that here. So I used to just never even take those calls until I realized that I was missing people that could really use my help. There are all sorts of reasons why you wouldn't want to testify in court. And I very much dislike the way that the state of California treats alleged victims of domestic violence like children who don't know what is good for them. If you are the alleged victim in a criminal case, you received a subpoena and you don't want to testify and you are looking to hire an attorney for that, be sure to click the link down below to book a consultation with me. Don't call my office. They may get confused and not book you for a consultation because for a long time I didn't take these cases, but I am here now. I can definitely help you. Just go ahead and click on that link down below. I hope you found this video helpful. And don't forget to subscribe, ring the bell if you did.